if the process of our constitutional form of government is followed, then you have to respect that that's what it is. And so if there's same-sex marriage in a state that has voted on it either directly by the people's vote or by the elected representatives, I would disagree with it as being a valid definition of marriage. But there's sometimes that you accept the law even if you don't agree with it. But what you don't accept is bypassing the process. And Michael, this is where I think a lot of elites, because I've been just drilled by TV hosts over the past week.
I can
imagine.
imagine.
How dare you say that, it's not the law of the land, because that's their phrase. It's the law of the land. Michael, Dred Scott decision of 1857 still remains to this day the law of the land, which says that black people aren't fully human. Does anybody still follow the Dred Scott Supreme Court decision?
Well, the Dred Scott decision was overturned by the 13th Amendment. And if you go look at the Lincoln-Douglas debates in 1858, right after the Dred Scott decision was adjudicated, Governor, and seriously, it's right there. Lincoln says we must respect this decision as the will of the court, but I think it was wrongly decided, and now we must overcome it. And in other words, to recognize that Obergefell is the law of the land right now doesn't mean that you accept it permanently. But I'm just curious, would you try to undo it with constitutional amendment as we did with the 13th Amendment and the Dred Scott decision?
I don't think that's necessary, because in the case of this decision, it goes back to what Jefferson said, that if a decision is rendered that is not borne out by the will of the people, either through their elected representatives and gone through the process, if you just say it's the law of the land because the court decided, then Jefferson said, you now have surrendered to judicial tyranny. John Roberts said the same thing in the dissent, that now 320 million people in America are being governed, not by their duly elected representatives, according to the Constitution. They are being governed by 5 unelected lawyers. So I just want to remind people that the basic fundamental principle of how you make a law is that Congress makes a law, a president signs it, a court can review it, interpret it, but it cannot make it. The Supreme Court in the same-sex marriage decision made a law. They made it up, and they made it up out of thin air. Therefore, until Congress decides to codify that and give it a statute, it's really not an operative law. And that's why what Kim Davis did was operate under not only the Kentucky Constitution, which was the law under which she was elected, but she's operating under the fact that there is no statute in her state nor at the federal level that authorizes her. No.